Kendall Mead versus the City of Owasso. Are you Mr. Mead?
Yes, sir.
Yeah, have a seat, please. And then we have Mr. Scott Gould here. He's the city attorney for Owasso. This is the City of Owasso's motion for summary disposition. I have read the motion and I have read the response. Mr. Gould, are you ready with your argument?
I am, Your Honor.
All right, you may step up and proceed.
Before I get into the actual legal argument, there's a few preliminary matters that I think have to be brought before this court, and they are very much related to this very summary disposition. City of Owasso filed a motion for summary disposition. Mr. Mead responded. Having researched Mr. Mead's answer to the summary disposition, it came to light after going in circles for some time that the case law cited, the opinions apparently rendered by some court, are in fact fictitious. I have reason to believe that AI probably helped Mr. Mead in this, and because I went round and round, second guessing myself about these case laws, about whether there were courts out there having these different opinions about municipal law, I finally had to reach out to a colleague who's also a municipal attorney, Justin English. I had him review the same cases, and with those cases, I have an affidavit from his office whereby he himself, using different tools of research than which that I have used, saying that these cases are in fact fictitious. I have an affidavit here by Mr. English, if the court's so inclined to.
Why didn't you file a reply and include it in a reply, Mr. Gould?
Well, Your Honor, I will say that as I kept researching this matter, I for lack of my own confidence, I thought I was missing something. I kept chasing ghosts out there. And
that's why they call them hallucinations.
Yeah.
Right? Fake cases, fake AI cases are called hallucinations.
Oh, that actual name? Okay.
Yeah, that's what they call them. They call them hallucinations. Oh, I'm well aware. I've done the same thing you have.
And it really comes down to really that, Your Honor. This is the first encounter that I have where I've had opposing counsel rely on that platform so much without verifying in some other fashion. And that is a problem that I incurred. This is the first time I've experienced that. That's the reason why I didn't file that in advance.
It's pretty unsettling, isn't it?
It is. It's concerning, and Owasso is my hometown, and it bothers me that, you know, this is serious stuff. This is an expense to the taxpayers. I mean, I'm not trying to talk myself out of a job, but making allegations and then coming to this court with fictitious court names and opinions is dangerous in a lot of ways, and it's concerning. So it really came down to I had to reach out to somebody else, make sure I wasn't losing my mind, so to say.
Well, why don't we get through the argument? I'm well aware of the hallucinations, Mr. Gould, and I'll address those directly with Mr. Mead when it's his turn to speak.
Thank you, Your Honor.
You're welcome.
The city itself is aware that there's no section 5.10 in Owasso City Code, nor is there any special permit scheme for chickens. The plaintiff is asking this court to strike down a licensing system that does not even exist. Owasso does have an ordinance prohibiting fowl, chickens, the raising thereof inside the city. That section is 5.4. And it clearly states that no person shall keep or house any animal or domestic fowl within the city except for indoor household pets. The plaintiff, when you look at his answer, it's pretty forthcoming. The plaintiff states in the statement of facts, provides that the city, with all the evidence needed for summary disposition, in that he admits to acquiring laying hens. That's not disputed. He admits to housing them in an outdoor predator-proof coop. He admits to allowing them to free-range access on his residential yard. And it doesn't matter how peaceful the hens are or hygienic the hens may be. It's still a violation. The housing in that area is very dense. In fact, the generally accepted agricultural management practices sets out setbacks for any kind of livestock in highly dense residential areas. And that setback is 250 feet to the nearest non-agricultural neighbor. Well, those lots inside that area, and I have a map that the court's so inclined to see how dense that area is, the lots themselves can't be more than 110 feet each. And so there's no way that even if you gave him the benefit of the doubt of being a farmer and you went and looked at the generally accepted agricultural management practices, he would even qualify by state's standards. Therefore, it's my opinion that the Right to Farm Act is not even applicable in this scenario. And that's what he's obligated to do. To date, I don't have a witness list. I don't have exhibits. I don't have anything that I can rely on for him to tell me that he's in fact compliant with Michigan's agricultural standards. I don't have anything that suggests or shows me that he's in fact a farmer. We're on the cusp of trial now at this point, and I don't believe he can even raise this matter now.
I moved into that house in Owasso without even properly realizing that it was a separate city than Corona. I'm originally from East Lansing, but like I lived outside the state for the majority of my life and moved back in 2018 to northern, the Traverse area. But yeah, I purchased what I thought was legal chickens, and I maintained what I thought was legal compliance, which Mr. Gould here has, found reference to in my documents. I thought I was maintaining compliance for what were the laws in Corona. When informed that I was no longer in compliance, I also filed an objection here after being referred around in my attempt. And I mentioned the RTFA partially in reference to a business that I've formed in February of 2025. So it's a young enough business that I've never actually filed tax returns. A lot of the paperwork that has been requested by Mr. Gould does not yet properly exist. So, I mean, there's been some problems for ability to serve responses in terms of that. I've attended mediation. I'm jumping around in the story here.
I just really need you to respond to Mr. Gould's motion. This is your time to argue, so I just really want you to stick with the points that he made.
Okay, so the issues of material fact, that's probably the most important one to go with.
Actually, it's kind of important. My mind is this deal with these cases. Much like Mr. Gould, I spent a lot of time looking at the cases that you cited, and I can't find that these cases exist. Where'd you get these cases that you cited?
Google and a lot of AI research.
You used AI, didn't you?
I will freely admit it for the research. I'm not trying to waste your time.
You didn't check and make sure that those are real cases, did you?
Not on every one of them, unfortunately.
So that's very bad, Mr. Mead. Because when you cite a case that isn't good law, you're misrepresenting the law, not only to Mr. Gould, but to the court.
Understood.
When you cite a case, when you cite a case, you're telling the world, look, this is the law that you need to follow, Judge Stewart. This is what I'm representing. And then when it's not, it's a misrepresentation.
It's only the misrepresentation that I was under the impression of also.
Oh, I don't understand that.
I was led to the impression that was, I should have checked. I freely admit, I apologize for that.
Okay.
I did my best to check on as many of those as I could, but my time is limited.
So because your time is limited, Mr. Gould and then this court had spent a lot of time trying to verify your cases.
So
whose time is limited, yours or ours? I mean, we spent a lot of time looking at the 5 cases that you cited, and you said you didn't have time to check them, to verify them, right?
I'm not saying that at all.
That's what you said. You said my time was limited. That's kind of disrespectful. Your time was limited, so you didn't check your sites and shifted the burden to the court and to Mr. Gould's office to determine the accuracy of your sites.
It's very disrespectful of me to do that, but I assure you that was not my intention. My intention was to relay what I had assumed was accurate information on the basis of the amount of checking that I had done of the citations previous to that. So it's not that every response from an artificial intelligence agent is completely hallucination. There's a mixture of accurate information, real citations.
And if you know that, that's even more troubling to me. You know that there's hallucinations out there and you didn't double check your sites.
Your Honor, for these proceedings, I'm somewhat overcome by the requirements of the paperwork and the amount of research that has been required. No, you said you intentionally included a legal site, a case site, that you knew might have been a hallucination. No, sir.
You just said, I know that some in AI, some of it's accurate, some of it's hallucinations.
Allow me to clarify.
But that's what you said.
I'm aware that it's possible that they could get through, but my intention...
So knowing that, you didn't check and make sure the site was legit?
I thought I had checked every reference that had gotten through 2 submissions to the court.
So you just happened to not check the 5 cases that you cited?
Your Honor, that was 5 cases in a volume of probably 30 or 40 cases that I was also researching.
But you cited 1, 2, 3, 4, you cited 4 cases at the beginning of your answer, and you laid them all out in the middle in bullet points. And you said, my time is limited, I checked some of them, but yet you led your brief with these 5 cases.
And Your Honor, this is my first ever legal case. I apologize.
This doesn't have anything to do with the legal case. This is lying. This doesn't have anything to do with being a lawyer or being a non-lawyer. This is putting a case out there for the court and representing to the court that it's true and it's accurate. That has nothing to do with being a lawyer.
Your Honor, I put nothing in there that I knew to be misrepresentation.
But you did, because you just said sometimes that AI can give you inaccurate results. You're just digging yourself in a hole. You better continue with your argument then.
Accounting for the presence of what are miscitations in my argument still stands that the law as enacted by the City of Wassos is ultra vires in 2 counts. On the first count, it's ultra vires in trying to ban chickens on the basis of a law that makes no concession to any form of regulation of chicken ownership. I have a copy of this law here if you'd like to see it, but I can read it in its entirety.
I'm not asking, you're not reading that in its entirety.
Okay.
No, thank you. It's surprising in this case because plaintiff's brief contains a fair bit of material that really demands a reply. It looks like Mr. Gould is working on it. And has actually had another attorney assisting him with it. Much of the case law in plaintiff's brief is fabricated, or what we refer to as an AI hallucination. Plaintiff cites 4 cases on the second page of his brief and provides what he claims to be direct quotes from those cases. First, 313 Mishap 104, he claims it's a 2015 case. Plaintiff identifies this as Bingham Farms versus Lawrence. But if you go to that site, it actually takes you to MEEMIC versus Michigan Millers Mutual Insurance. Plaintiff specifically cited at page 116 of that opinion, which is actually from a case called Chiropractors Rehabilitation Group versus State Farm. And there is a Bingham Farms. We found it, and that case didn't involve chickens, but it involved sewers and waters. Municipalities arguing over access to sewers and waters. Plaintiff's next cites to a case that he calls Hatfield versus Township of Heartland, a 221 case identified as a Court of Appeals docket number 354103. That docket number points to a case called In Re BS. I'm not pointing out the irony of this name in the bench opinion, but that's an adoption case, and it's unsurprisingly silent on the issue of keeping of chickens. The next case cited by plaintiff, Farms Not Factories versus the City of Lansing. Court of Appeals docket 367891. But that docket number belongs to a case called Henry H. McClinton, another adoption matter. Here's another case, Adams versus City of Battle Creek. For this case, plaintiff provided a bogus Westlaw citation that doesn't return any case at all. In fact, Westlaw citations are 7-digit citation numbers, and this was 1, 2, 3, 4, 5, 6, 7. The odds of a case with a citation of 1, 2, 3, 4, 5, 6, 7 is 1 in millions. I've never seen in my career as a judge and attorney seen more than 3 sequential numbers in a case cite, let alone 7. The court found a 2001 wiretapping case by that name, but it has no bearing on this matter. He also cites to Williamstown versus Sandalwood Ranch, 325 Mishap 541. That's a 2018 case. The citation checks out, but that case involves latches applied against a plaintiff municipality. Defendant corporation asserted affirmative defense of latches, and the Court of Appeals held that the corporation failed to produce evidence to substantiate the defense. Next, plaintiff cites 478 Mish 908, claiming it is Papadelis, Papadelis versus City of Troy. That citation could point to short orders on 2 other cases, neither of which are consistent with plaintiff's brief. The reason why I spent so much time talking about these hallucinations is that I spent a lot of time trying to hunt down the law. Apparently, Mr. Gould did too. It's incredibly inconvenient when the attorneys and judges and court staff are trying to make sure we get it right by finding the correct law. And this wasn't that. And by signing your answer to the motion, Mr. Mead, you certified that your response was warranted by existing law, pursuant to MCR 1.109E5. The court isn't going to sanction you today. The court is just going to admonish you for misrepresenting the law. And I'll leave the issue of attorney fees to Mr. Gould. If he wants to file a separate motion for attorney fees and lay out what you've done and what your position is, and based on the law, I'll consider it, but I'm just not going to do it today. But what the court is going to do is strike the plaintiff's answer in the offending brief. And I think that's a fair remedy. I'm just striking it. That means that the court will treat the motion as though no response has been filed. That said, even if the court does consider the brief, even if it did, the plaintiff would not prevail at the motion hearing. Plaintiff argues that genuine issues of material fact preclude granting the motion, but plaintiff didn't attach any documentary evidence in support of his position, meaning he can't and didn't show a genuine issue for trial. Plaintiff's response also did not address the C8 components of defendant's motion. So that aspect of the motion is truly unopposed, at least on the papers. So for all those reasons, the motion for summary disposition based on C8 and C10 is granted, and this case is dismissed. Mr. Gould, please prepare an order, and I'll leave it to you if you want a remedy on the AI.
I appreciate it, Your Honor. Thank you.
Thank you all. We're in recess.
All right, we're back on record. State versus Alan Shoemaker. Do you know an Alan Shoemaker?
Yes, I do.
And how do you know Alan?
We were married for 36 years.
At some point, did you file for divorce?
Yes, I did.
When was the divorce filed?
In June of 2019.
Was the divorce amicable? Did everyone get along?
No.
Why is that?
Well, Alan didn't seem to accept that we would be divorced, so he fought it.
Did you file a CPO against the defendant in 2023?
Yes, I did.
Why is that?
Well, because I was receiving mail that had what could be seen as threatening content.
Around September 17th, 2024, did you receive mail?
Yes, I did.
Do you recognize the writing in that letter?
Yes, I do.
And whose writing is it?
That's Alan's writing.
Is there a Mary Grace reference?
Yes, there is a Mary Grace reference.
Do you know a Mary Grace?
I do not.
Has he ever sent other letters in care of a Grace Shoemaker or a Mary Grace Shoemaker?
Yes, he does.
Does a Mary Grace Shoemaker live with you?
No.
After you received this letter, what did you do with it?
I took it to the sheriff's department and filed a complaint.
Around September 30th, 2024, did you receive mail?
Yeah,
Where did you receive your mail?
at my home address.
After you received this letter, what did you do with it?
Took it to the sheriff's department to file a complaint.
Gotcha. Around May 1st, 2025, did you receive mail?
Yes.
Among those names, there is an Angie Roush. Do you know who that is?
Yes, she was my supervisor at work.
Work? Mm-hmm. There's also a Teresa Rhodes. Do you know who that is?
Yes, she was my coworker.
And to your knowledge, is there any connection between your children and either Angie Roush or Teresa Rhodes?
No.
When you received this letter, did you understand it to be intended for you or your household?
Yes.
And then after you received it, what did you do with it?
I took it to the sheriff's department to file a complaint.
On June 18th, 2025, did you receive mail?
Yes.
And what does that letter specifically say about Dr. Drew?
Give Miss Collins Dr. Drew's information.
To your knowledge, was the defendant aware that you were seeing Dr. Drew?
Yes.
And then after you received it, what did you do with it?
I took it to the sheriff's department to file a complaint.
No further questions.
All right, Mr. Shoemaker, if you wish to ask the witness questions, may do so at this time. Stand at the lectern, please.
You received those letters?
Correct.
And you opened them?
No,
You didn't open them?
no,
You gave them to Ethan,
yes.
and then he gave them back to you?
He came to the house and he opened them and read them and left them at the house.
Okay. Did he ever receive any other mail at that address?
Yes,
So that was an address where he had told me that if I needed to get a hold of him to send letters to that address.
Objection.
I'll sustain that you're not permitted to testify at this point. You have to ask questions.
Right. Where do you work? Okay, what is that? What does it do?
Objection. Relevance.
I'll allow that question. We're not going to go too deeply, but she can answer that.
we're a computer distribution and configuration center.
And that company has a, I want to say a tech department.
Correct.
And what does that department do?
Objection.
Okay, I'll sustain that. That's not relevant.
When I was in Madison, I took a year of computer classes. In that class, you can take a copy of a letter.
I'm going to object. This is.
Okay, I'm going to sustain that. You're not asking a question. You're testifying. So the jury will disregard that.
The purpose of the tech room is to set up computers to make them work like the customer would like them to work.
Objection, Your Honor. This is not relevant to the charge.
I'm going to sustain that. There's no relevance here. So move on to something else.
Okay. I guess at this time I have no further questions. I'd like to call Michael Johnson Sr.
Michael Johnson, Sr.
Correct. And where do you reside at this time?
Lake Erie Correctional Institute.
And this is where we met?
Yes.
How close were we?
Side by side in the same cube, bottom racks, here right across from me.
We basically went pretty much everywhere together. We went to the chow hall.
Objection.
Together.
He's testifying.
Yeah, that's called leading. You're not allowed to do that. You have to ask questions, so the objection is sustained.
You basically saw him.
Objection. He's leading.
Yeah, you have to ask questions. You can't lead.
Right. Did you see me write letters while we were at there?
Yes.
Do you know who those letters were written to?
Yeah, to the church people that you had that sent you the food box.
So you basically seen every letter that I...
Yeah, I'm going to sustain it. You cannot put words in his mouth. You have to ask him questions.
Right. Okay.
So that's sustained.
So you never really seen me write a letter to Teresa Shoemaker?
No. Never.
It was always to one of my kids.
Yep. Actually, I think it was your son.
So basically, you're saying that we were basically...
Objection.
Sustained.
No further questions. Thank you.
All right. Cross?
Mr. Johnson, have you ever been convicted of felony in the past 10 years?
Yeah.
Is it 1? Is it 2, 3? Do you know how many?
Just one.
And what was it?
It was called, well, it was domestic violence when it first started. They worked it down to something else.
Would menacing by stalking?
Yeah, that's what they made that up. I mean, there was never no stalking or nothing. Me and my girl was together for the whole time.
But you either were convicted or you pled guilty to that and you were...
Well, I pled guilty to that to get a bond, personal bond, after being in jail for 5 months or 6 months.
Menacing by stalking, that's after being told to leave someone alone, you continue to harass them. That's basically what the charge is, correct?
She was the one that came pick me up from the jail, too.
Nothing else. Ladies and gentlemen of the jury, I told you when we started today that we would present testimony and evidence necessary to prove that this defendant violated a protection order on 4 separate occasions. He did this when he sent 4 separate letters to his ex-wife, Teresa Shoemaker. We're now at the end of the trial, and we have proven exactly that. The defendant and Teresa Shoemaker were officially divorced in July 2019. Due to continued contact and harassment, Teresa filed for a protection order prohibiting the defendant from having any contact in June of 2023. These are very simple, straightforward, irrefutable facts of this case. This defendant violated the terms and conditions of the protection order. This is a felony because this defendant has previously been convicted of this crime. As such, I'm asking that you find this defendant guilty of all 4 counts. Thank you.
All right, Mr. Shoemaker, you have the opportunity to make a closing argument on your own behalf.
The letters was written to my kids. Their name was on the outside, their name was on the inside. The only name on the protection order is Teresa's name. Her name was never mentioned. So that's basically all I've got. Thank you very much.
All right, court's been informed that the jury has reached a verdict, and Mr. Link, you're the foreperson. If you would hand those to the clerk, please.
In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Alan W. Shoemaker. Case number 25 CR 124. Verdict, count 1, violating a protection order or consent agreement. Revised Code 2919.27A1. We, the jury, having been duly impaneled and sworn, find the defendant, Alan W. Shoemaker, guilty of violating a protection order or consent agreement as he stands charged in count 1 of the indictment. We further find that the defendant was previously convicted of violating a protection order or consent agreement as alleged in the count 1 of the indictment.
All right, then, ladies and gentlemen, first of all, the court will accept the findings of the jury and then findings of guilty on each of the 4 counts that was set forth in the verdict forms. Now, ladies and gentlemen, that'll complete your service. I want to thank you for your service. And I'm going to step off, and if everybody would remain, please. All right, anything from the state regarding sentencing?
Your Honor, we would ask for 4 consecutive sentences as these are 4 separate events.
All right, Mr. Shoemaker, is there anything you would like to say on your own behalf?
No, sir.
Because this has been going on since 2019, and in trouble because of 2 things. Pen and paper. Yeah. The only person I know that seems determined to stay in prison. Because you've been convicted over and over again. 2019, violated protection order. 2019, breaking in, and I think that started out maybe as burglary. And then also menacing by stalking and violating protection order. So that's 2 violations. Failure to appear in 2019. 2020, violating protection order. There's 3. 2023, violating protection order. There's 4. All of these because you're writing and sending stuff to your ex-wife. No reason to communicate with her. You know that your kids don't live with her, but you continue to send her stuff. You want to try to stay in her mind. I understand that you have deeply founded religious beliefs, but that's no excuse for violating the law. In the eyes of God, as still married to this woman, that's fine. But mental health evaluation, they said you finally admitted that in the eyes of the law you're divorced. So why would you want to send something to her? Why? There's just no reason. There is no reason at all, except you want to continue to harass this woman and to keep her upset.
Not harassment.
Well, you continue to do it. There's no other reason. You have no legitimate reason.
The Bible tells me I should.
No, the Bible doesn't. God doesn't tell you to violate the law and harass your ex-wife.
It says to be a watchman.
And you have no right to do that. And there's no doubt in my mind that the only thing that's going to stop you is death. And so it requires for her protection. Because quite honestly, one of my concerns has been over the last, because it's been going on for so long, is that you might finally get smart, quit doing it so you can get out. And then, my concern would be that you would cause her physical harm. But you continue to write letters, and you'll probably continue to do so because you can't stop yourself, or you won't stop yourself. So the only thing I can do to protect her is to make sure that you stay in custody as long as possible for these violations. Justifies the maximum sentence. If there was ever a justification for it, it's this case. This is not a TCAP case, which was require the time to be served in the county jail. So in this case, this time is to be served in prison. So it is the judgment and order of the court that you be and are hereby sentenced on each of the 4 counts to the maximum term of 12 months. Now, as the court has indicated, this is, with these 4 convictions, that brings your total 8 convictions for violating protection order, plus a felony B&E, plus a felony menacing by stalking, plus a failure to appear. And so your criminal history demonstrates that it's necessary to impose a consecutive sentence to protect the public, and in particular, your victim, Ms. Shoemaker. The court also finds this a course of continuing conduct. 1 single prison term is not adequate to reflect the seriousness of your conduct. And the harm is so great because, again, this woman just wants to live in peace, and you won't let her. You won't let her. No matter what you believe under your view of God's word, does that justify harming her and ruining her, continuing to harass her? No. If you want to live in your belief you're still married in the eyes of God, that's fine. Just don't say anything to her about it. Leave her alone. It's necessary to deter you from committing future crime and to punish you because, obviously the past sentences, and some of them were minimum sentences, some of them were range sentences, it hasn't worked. And your release, if that ever happens, I don't know. Again, I'm not optimistic. It won't be my problem because I'll be long retired. But in any event, if you do get released from custody in the future, it is possible the adult parole authority would put you under post-release control supervision. I certainly hope that they do. But again, that'll be up to them. It could be for a maximum of 2 years. That means you'll be supervised under the terms they set by a parole officer. And if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. All right, is there anything further, counsel?
No, Your Honor.
You have anything else, Mr. Shoemaker?
No, sir. No, sir.
All right, you're remanded to custody.
Judge, do you want him to sign this?
Nah.
Yeah.